right, we are back, and joining me now is a nice gentleman named Andy Jung. He is an associate counsel. He's a lawyer who works as associate counsel at Tech Freedom, focuses on technology law and policy such as antitrust, Section 230, and online privacy. And today we're talking about some lawsuits that have to do with government trying to regulate speech. And Andy, welcome to the show, first of all.
Thank you so much. It's really great to be here.
So tell me about NetChoice LLC versus Paxton and Moody versus NetChoice LLC. What are these cases about fundamentally?
So these are two cases that are before the Supreme Court right now. And they're focused on the content moderation decisions of social media platforms. So the content they leave up, the content they take down. And Florida and Texas passed two laws that would curtail the ability of social media platforms to take down or leave up certain content. And the online platforms challenged those laws on First Amendment free speech grounds, and they've made their way to the Supreme Court right now. So that's why everyone's been hearing about them in the news.
So what are you up to speed on how the justices received the arguments? That's always how we parse these Supreme Court decisions and how we try to figure out what the Supreme Court might do. Were they receptive to the government's argument, or were they more receptive to the net's arguments?
Yeah, so it's the Florida and Texas arguments versus sort of the technology companies' arguments. And it's really difficult to say at this stage. Recently, they held oral arguments. And so I listened into the oral arguments, and you can try and make predictions based on the questions the Supreme Court justice asks, but I will not get myself in trouble doing that. But what's clear is that the case will be decided along First Amendment grounds. So it's a very major case in terms of how First Amendment free speech and how those rights apply to the internet.
So let me ask this. We think of free speech more in terms of what you say, right? My ability to say what I want to say. But what we're looking at here is a company's ability to pull down content that they may philosophically disagree with. How is that different?
So, when lawyers talk about free speech, what we're talking about is the First Amendment. And what's important to remember is that the First Amendment actually applies to the government. So the First Amendment prohibits the government from taking certain actions. The First Amendment doesn't apply to companies like Google or Facebook. It doesn't prohibit activity by them. The First Amendment actually prohibits the government from taking certain activity on those companies instead. And so, the conversation, if you talk about free speech, the conversation can get a little bit confusing. People are saying, I should be free to post what I want on Facebook. But what the Supreme Court is deciding is the First Amendment and really what leeway the government has to tell these social media platforms to leave up content, to take down content, and just to provide feedback in those decisions or to ask for explanations for those decisions. Those are the kind of things that Florida and Texas want the social media companies to do. And the social media companies are arguing, the First Amendment actually protects our right to free speech as private entities. You, the government, can't impede on that. And our free speech includes our content moderation decisions.
Are both of these laws written equally? I've read that the Florida law is quite sloppy. Is there any chance that one will be struck down and one will be upheld, or will they both go or both stay?
It's a tough procedural question, but to the extent that the decision is made on First Amendment grounds, probably both will go or both will stay, or similar elements of both laws will either stay or go. At a high level, what both of the laws are asking for are somewhat twofold. The first are you have to be content neutral in your content moderation decisions. And the second set of requirements are disclosure requirements. So if you, for example, ban a user from a platform, we have to provide an explanation to that user and hear the details of the explanation. So those are the two issues that are before the court right now.
So
those two aspects.
Let's talk about the content moderation aspect of it, because, it seems that, and this is where these laws came from, it seems that conservative viewpoints were moderated more than, opposing views. So how does that all play into it? Does the content of what's being moderated matter at all? Because that's kind of the argument that Texas and Florida are making. And if not, why not?
Texas and Florida are making that argument. They're concerned that the social media companies are biased against conservative viewpoints. And perhaps you agree with that. Perhaps conservatives are irritated by some content moderation decisions that platforms have made. But either way, the question we need to ask ourselves is whether you want the government making those content moderation decisions instead. These are private companies. They have values. I think the main value these platforms have is that they want their users to have a good time. So they remove content that they think users don't want to see. And politicians have politicized those decisions to say, no, they're trying to silence certain viewpoints. I'm not sure that's happening, but even if that is happening, we don't want the government making those decisions, stepping in, confusing issues that really just come down to that are covered by the First Amendment clearly of these social media platforms. I shouldn't say clearly. The contours are being currently debated within the Supreme Court, but it's clear the First Amendment protects these private companies online.
So how does this compare with the 303 Creative case? Because we've had more than our share of these cases out of Colorado where someone has tried to force someone to express something that violated their personally held beliefs. How is this similar or different from the government saying you can't force a web designer to make a website that is in support of something she doesn't believe in? How is this similar or different?
Yeah, great question. So a similar issue in those two cases is that in both cases, the government before the court tried to argue that these content moderation decisions of social media platforms are in the case of 303 Creative was the Baker. But they tried to the government tried to categorize. They tried to classify
yes,
speech as conduct. And in doing so, they're trying to argue that no, these decisions to bake a cake or not, or to host this content or not, is actually conduct. That's not expressive speech. And I think what's interesting is that in 303 Creative, that was the Biden administration advancing that argument. So a Democratic administration, Democrats, left leaning. And then in the net choice litigation, you have conservative states, Republican-led states, Florida and Texas, also making that same argument, saying that, no, this is conduct. This isn't speech. Don't worry, we can regulate this. And my point is that, if we lean into this, neither side wins. Both sides will try and argue that taking down content that they support is actually conduct, and therefore it's okay to punish companies for doing that. And in doing so, nobody wins.
And that is because I've been pretty vocal about my frustrations with the content moderation that I've seen on social media platforms. But, as I always say, who gets to be the decider if we give it to the government? What group of people do I get to be on that panel? Because if I'm on the panel, yay. But if I'm not, then I have some grave reservations about this. So though I find it extremely unsatisfactory that tech companies overall have such an outsized influence in our society at this juncture, right? They have so much ability to reach so many people with whatever messaging they choose, but there's not a better way. There's not a better way to do this without creating a new government agency whose sole purpose would be to curtail speech that whoever was in charge of that agency didn't like. So am I reading this right?
I think so. I mean, another point I'd like to make, and I think really applies here, is that regardless of where we fall in these policy debates, laws must be constitutional. And the First Amendment makes clear that it's not the government's role to be the arbiter of truth in these debates, whether it's in newspapers or whether it's on the internet. And so, we can be upset about the content moderation decisions or that social media companies make, or the articles that newspapers do or do not post. But it would be worse and impractical and unworkable for actually the government to be making all those decisions, bearing in mind that social media companies make millions, if not billions, of content moderation decisions a day. And we see how few bills Congress is able to pass, just for example. So take those two things into account in terms of the ability of the government to do it better than social media companies.
Andy Jung with the Associate Counsel for Tech Freedom. Thank you so much for your time today and sort of wading through this, because as kind of boring and dense as it is, it has really far-reaching ramifications. And I think it's really important that people understand
these are important cases, and I'm really happy to come speak with you about them today.
All right. Thanks, Andy.
Thank you so much.